First case on this morning's docket. Case number 115227, State of Kansas v. Jeremy Clarout.
Good morning. May it please the court. Meryl Carver-Ullman, Capital Appellate Defender, on behalf of Mr. Clarout and Chief Justice Nuss, may I please have 3 minutes rebuttal?
3 minutes is granted.
Thank you, Your Honor. This case stems from a pretty tragic accident that happened in Johnson County. My client was undisputedly very drunk and got behind the wheel of his truck and went driving and got into an accident in which Mr. Wildermuth, the victim in this case, was killed. He was charged with reckless second-degree murder as a result of those crimes. The case went to trial. My client went in and I think in opening argument even admitted that he was guilty of DUI manslaughter but contested the elevation to second-degree murder. He raised a couple of issues kind of throughout that we're raising today. One was he wanted a voluntary intoxication instruction to be given. One was some prior bad acts evidence, and one was a Daubert issue. So ended up losing at trial, was convicted of second-degree murder. We appealed to the Court of Appeals. They affirmed his convictions with Judge Green dissenting on the prior bad acts issue, and that is basically how we got to where we are today. My plan today is to start actually with the voluntary intoxication instruction, hopefully get to a little bit of the 455 issue, and probably submit the Daubert issue on the brief. So to start in on the voluntary intoxication instruction, the defendant requested a voluntary intoxication instruction that said, voluntary intoxication may be a defense to all of the reckless crimes and lessers that were charged here when the intoxication impaired the defendant's mental facilities to the extent he was incapable of consciously realizing the risk his actions posed to others. So that is the requested instruction. We're under the requested instruction standard, and really what we're talking about here is whether this is legally appropriate. I don't think there's a real serious debate that if it was legally appropriate, it wouldn't be factually appropriate. The state argues some cases from other states and some pre-recodification stuff, but that really isn't relevant post-recodification. Our recodification changed the mental states pretty fundamentally, I think, as this court has recognized in other cases. So really we're kind of left, I think, with the plain language of the statute. And if you look at the plain language of the statute, he had to commit this crime recklessly, and recklessly is defined as consciously disregarding a substantial risk that circumstances exist or that a result will follow. To me, this is a lot like premeditation. When you have premeditated first-degree murder, you have to premeditate, and then you have to do the thing, kill the person. Sure.
Start with a very basic question. He acknowledged that he was reckless in his behavior, didn't he? By basically, he didn't plead to it, but acknowledging that he did commit the involuntary manslaughter, which requires a reckless state of mind, doesn't it?
I was looking at the involuntary manslaughter statute last night, and I think that's, the Court of Appeals said that. I agree with you. That's a misreading of the statute. If you look at the statute, it says involuntary manslaughter is the killing of a human, 1, reckless, 2, something else, and then I think we get down to 3, and it's DUI manslaughter. I think that there is case law that I'm not going to be able to pull off the top of my head right this second, but it would be a surprise to me if this court ruled that DUI manslaughter is not strict liability, because that's always how we've gone forward. So I think he did not admit to reckless behavior in basically admitting to DUI manslaughter. If those are alternative means, really, if you read the statute, if those are all ands, then I don't think anybody could ever commit involuntary manslaughter, actually, because you would have to do all of the things. So
you think the Court of Appeals got it wrong when they said he stipulated to being reckless?
Yes, I do. Okay. So one case that is helpful in all of this is this court's recent decision in Murin. And I think I misstated a little bit in the 609 letter that I filed in March, because I think I was talking about the extreme indifference to human life, and I meant to say consciously disregard the risk. But that's what we're arguing about here, is really the conscious disregard of the risk. And the Court of Appeals sort of sidestepped that by focusing on the circumstances showing indifference to human life. But that's not the state of mind that we're talking about here. We're talking about that conscious disregard. And Murin talked about it being sort of a standalone element. And again, I think it's like premeditation here. You have to look at the risk, realize, hey, that seems like a really stupid thing to do, and then do it anyway. There are two steps there, as opposed to a normal knowing act where it all kind of merges into one act.
I've been struggling with this. I don't understand how driving 80 or 90 miles an hour on a city street for no good reason in a large pickup truck isn't a pretty good example of a conscious disregard to the risk.
I think if he had been sober, sure. Absolutely. But
Do you think he didn't know that he was driving?
I think it's possible.
That he accelerated to 80 or 90 miles an hour on a city street?
I do think it's possible. If you look at the evidence in this case, he had been drinking since some of this is contested evidence a little bit, but in the main, he had been drinking since very early that afternoon, and drinking, I mean, not tiny beers. Both of his friends were with him who had been drinking at a similar rate, said that their judgment was impaired. They were having trouble perceiving and remembering things. The officers that were at the scene agreed with that assessment of their behavior. He was so drunk, they were so drunk they didn't even realize that they had hit another car.
Isn't that sort of the gravamen of the crime? That it's impaired judgment.
That's sort of the crux of this case, because if he could consciously make the decision that this is a bad idea and do it anyway, then yes, Russian roulette.
So every DUI case gets a voluntary intoxication instruction.
I don't think every case does. I mean, I think there's probably a threshold level of intoxication there.
So there is a factual element. You started out by saying there's no factual element. It's just purely a question of...
No, I think there's not a factual element in this case because there was so much evidence that he was very, very, very drunk.
So the drunker you are, the more likely it is that you'll get a voluntary intoxication.
And I, as a driver on Kansas roads, I think we may not like that, but I think that's what the legislature has done. I think the state in its brief, for example, says that, some states use high levels of intoxication as an aggravator. We don't. So that's
You're
that's
asking
where we
us
are.
to treat it as a mitigator, though.
Well, it's not a mitigator. It's a defense that he's entitled to under our statutes. And, we may not like that. I'm not sure I love it, but that's an argument for another body.
So it's your position that he was so drunk that he couldn't form the requisite, his judgment was impaired to the point where he couldn't be reckless, he couldn't show a reckless disregard?
Where he couldn't consciously disregard the risks that he was taking. He couldn't look at those risks.
So getting back to Justice Biles' point, the fact that he got in the car, turned the key, put the key in the ignition, turned it, maintained a single lane apparently. He was driving down the road at excessive speed. All of those factors that we would look at, he got out, smoked a cigarette. He had all those kind of faculties available to him, observed the damage to his truck. That wouldn't be some consideration we would take into account in making that determination if he was so impaired?
I think...
Why don't the facts enter into this determination here?
And of course there is always the question of, is it factually appropriate? Here, I'm arguing that it is.
And that's just based on the consumption of alcohol.
The consumption of alcohol and his behavior. Honestly, he was slurring words. He had a strong odor of alcohol about him. He pretty much failed miserably the sobriety test he was given. You know, and again, he didn't even realize he'd hit another car. I mean, how impaired do you have to be in that position? I think the only other thing I was going to note is the state cites this Keebert case from 2015, and it's actually an identical offense doctrine case, but in that case they actually say that to the extent it matters anymore, I'm not sure that specific intent versus general intent crimes even are as much a thing as they used to be. But the Keebert case actually says that reckless second-degree murder is charged here is a specific intent crime. So to the extent that that matters, there is at least one case out there that says that. If the court has questions about that issue, any more questions, I'd be happy to answer them. Otherwise, I'm going to go on to 455 in my 2 minutes that I have left. Mostly, I am happy to rely on Judge Green's dissent on this issue. I think it was a well-written dissent, a well-reasoned dissent, and this court should follow it. The one thing that I actually did have a problem with, I think we already talked about, Justice Rosen, which is they based their harmlessness finding on two things, essentially. And one was all of the facts that he was drunk, which I think go just as easily to it being DUI manslaughter as it does to it being reckless manslaughter. But then the other thing is I think the Court of Appeals misread the statute in assessing the harmlessness on the 455 issue, also in the same way that we discussed a minute ago.
Why isn't it a 6261 harmless analysis?
Here, I think...
In light of the entire record, why wouldn't it be that?
So I think that is a little bit up in the air from reviewing the cases on that. Judge Green obviously says it's constitutional because it's his right, based on his right to a fair trial. And, obviously I have one judge that agrees with me. I'm not going to retreat from that. That being said, some of the cases that the Court of Appeals cites, for example, Gumby, the portion of Gumby they cite to was talking about a limiting instruction, not whether the evidence comes in at all. Patton, which the Court of Appeals also cited, actually applies both statutory and constitutional harmless error. Sanders is about a hearsay objection. So I think the cases the Court of Appeals is citing aren't all squarely on point. That being said, there was one that definitely was, at least. I think it's a little up in the air, honestly, on what standard applies. And again, we would just go back to propensity evidence being admitted improperly goes to his right to a fair trial. And so that's why we're asking for the constitutional standard.
Do all evidentiary errors rise to a level of constitutional harmless error?
I don't think so.
And what's the test and where's the line?
Well, I don't know where the line is in a broader scope. I can say in this case, I think we've recognized that propensity evidence is so damaging. And in this case, it probably was very damaging because it really makes my client look like he has an alcohol problem and shouldn't be getting behind the wheel. And I could see as a juror in that case wanting to protect other people because he's a serial drunk driver and not necessarily because you found that he had the specific intent in this case. So I think where it's propensity evidence, I would argue for the constitutional standard. Other evidentiary errors I would have to think about on a case-by-case basis, I guess.
Well, the diversion agreement, as I understand it, was offered to show knowledge that he should, to kind of go to this reckless and the indifference to the value of human life. Mm-hmm. In that, it's here he signed this diversion agreement that said he would go to classes, that he would go to these victim impact panels. And that's what it was offered for. That's how it was argued. I mean, Judge Green took a different view of how it was argued, but you could see that it was argued that he should have known better because he went to these things and did these things. Why is that improper? What's wrong with that?
Well,
that's not propensity. That's arguing that it's being offered for what it was intended to offer, and that is he had a particularized knowledge about the dangers of DUI based upon this agreement.
I think one thing is you have to look at the district court's opinion, which is the district court said we're not going to get into all those classes. We're not going to get into what he learned we're going to just admit the fact of the prior DUI. So that's part of the problem here.
That's not true, though. That's where I go off on, because the document itself tells you about the classes. So that information's getting in with the document. It's not just the fact of the DUI. So it seems to fit the purpose. I really felt like the district court was trying to help your client by limiting the amount of discussion about the document and just putting it in, and there it is, guys, and within the four corners, the jury can read that last, I think it's the last paragraph on the document, it's on page 4, and see these classes. And that's what then communicates the seriousness of the DUI offense and puts your client on notice that it's important. So why am I wrong on that?
Well, I think, and whether the district court was trying to help out my client or not, we can debate about that probably. But I think if they had put on further information about the classes, it would have been relevant maybe to show what he learned in those classes. For example, I could conceive of a scenario in those classes where they say alcohol affects everyone differently. And my client has already driven while intoxicated and no one got hurt. So maybe alcohol affects me differently and I can drive while I'm intoxicated. We don't know what was presented in those classes. They never put evidence of that because of the district court's ruling. So that makes it, that hits at the relevance of it, I think. And I wish that the ruling below had been clearer, but we kind of are where we are on that. And I can't fix that now, obviously. But ultimately the district court's ruling was, we're not going to talk about the classes and stuff. To the extent the state did, they were probably violating the district court's order. And I think if they had gone into the classes more, it might have actually been more relevant. That might have helped the relevance. But just the fact of the prior DUI, really, for the reasons we've argued, isn't necessarily relevant. It didn't necessarily put him on notice any more than anybody else that driving while drunk is dangerous.
Any further questions? We've taken a lot of your time with our questions. Do you need 30 seconds to kind of wrap up or do that on rebuttal?
I'll probably be back. Thank you, Your Honor.
May it please the court, the state appears by Assistant District Attorney Kendall Kaut. Voluntary intoxication was not a defense to this crime, and Judge Welch was correct to not instruct the jury that it was a defense. The Murren decision, which is mentioned in the 609 letter that was filed by appellate counsel, does not create a new requirement that recklessness automatically now gets a state of mind instruction for voluntary intoxication. The line of questioning that Justice Stiegel asked about, I think, highlights kind of the ridiculousness of offering voluntary intoxication to a crime where it is alleged that part, and a major part, of the recklessness is that someone drove too drunk. Here, Mr. Claerhaut was 0.211. It creates sort of a donut hole of what I would call nonsense. You don't drink enough, you're not guilty of recklessness. You drink just enough, you're guilty. But then if you get a little bit too drunk now, you're not guilty again because you couldn't formulate the state of mind. There isn't that kind of state of mind requirement for recklessness. Their framework would ensure every single reckless case has to get a voluntary intoxication instruction. The conscious disregarding of the risk is what recklessness is. It is no different than knowledge. A person understands the result will follow, and they take the result. So under that framework, every knowledge case now gets a voluntary intoxication instruction. This court in Murren said, the state's argument now that all non-strict liability crimes get a voluntary intoxication instruction is unfounded. And this court went through and explained the differences between a criminal trespass statute and an obstruction statute and highlighted if there is not that separate knowledge requirement, we don't give the instruction. Here, there is not a separate knowledge requirement. If you look at the statute for reckless second-degree murder, it could not be clearer. It is murder that is unintentional but recklessly under circumstances manifesting an extreme indifference to the value of human life. The recklessly, but under circumstances manifesting extreme indifference to the value of human life is one clause following a conjunction. The conjunction starting with recklessly down to the end of manifesting extreme indifference to human life has no comma separating it. It follows the conjunction. It is one simple phrase. Do you show that extreme indifference, what we might think of as kind of reckless plus, as the wise panel of the Court of Appeals looked at it when we cite our brief? In this case, Mr. Claerhaut did that. He is not entitled to that instruction. But if he somehow were entitled to the instruction and you think, listen, we might not want
Is that all never entitled to the instruction under your argument here? Is that this under reckless second degree you never would get a voluntary intoxication defense?
That is our argument, Justice Rosen, yes. You would never get one under reckless second-degree murder. Now, I guess it is possible there's a circumstance I haven't thought of where maybe it would be appropriate, but I can't think of one off the top of my head, certainly, where it would apply. But I do think that it certainly would at least be harmless. Maybe the argument is correct that the legislature just messed up, and this court kind of went through in Hobbs and Yulteris, and now in Murrin, and mentioning that specific intent doesn't mean what it used to mean. And so we view knowledge a little bit differently in that line of cases that says if it's an aggravated battery for knowledge, you have to give a different culpable state of mind instruction. Maybe they screwed up. But if they did screw up, it is hard to imagine any world where a juror would get back there and say, you know what, he was just too drunk to have been reckless driving that night. The man was .211. As Justice Rosen's kind of line of questioning and what Justice Stiegel asked, I think is pretty persuasive here. He got in the car, he put the keys in the car, he was able to navigate a roundabout before he was going 90 miles an hour. He was able to think well enough to put his foot on the accelerator at 100% for that CDR download. He was able to think well enough to go to 3 different bars and then hopefully make it back to a 4th one, which was his plan. Able to think well enough to smoke cigarette after cigarette while officers asked him, please put those out. That showed he had the mindset and was able to formulate that extreme indifference to human life when he crashed into a man, caused him to go hundreds of feet, and caused him to die a month later. There is no question whatsoever under any standard of error that this was not error, and certainly if it was, that it would be harmless beyond a reasonable doubt. If there are no further questions on voluntary intoxication, I'll plan to turn to the 6455 issue. The 6455 issue is framed by the first part of that test. Is the evidence offered for a disputed material fact? And the brief filed by Mr. Claerhaut concedes in this case the DUI diversion was offered for a disputed material fact, namely whether he showed extreme indifference to human life. Judge Welch even framed it in her good analysis, which I think is on pages like 149 and 150 of that suppression hearing, and I think it was very detailed, and I think it did help her client out, if anything, as Justice Biles has alluded to. She outlined that it would be relevant because it's the main thing they argued about at trial. In opening statements, John Duma, the counsel for the defendant, argued, we are guilty as can be of involuntary manslaughter. But he tried to argue throughout the case they were not guilty of showing extreme indifference to human life. The DUI diversion, though, does become relevant to that fact, as Judge Welch found. She did not abuse her discretion, which this court has consistently held as the standard in Boysaw and in Torres in so many of its cases. There was no error of law, no error of fact, and certainly a reasonable person could take the view that a DUI diversion would put someone on notice about the dangers of drunk driving.
And you get that just by the diversion agreement, because it was limited just to the agreement. And I note that the agreement has the defendant's initials on it, that he agreed to all of this, but that's all they could get into. It's up for the jury to figure out what all this stuff means. I mean, she limited it to the extent where you really couldn't tell what any of this meant to a certain, that's the argument. Why isn't that right? I mean, if you can't get into what, did he attend classes? What do they entail? Why does the diversion agreement relevant in that way? It's just a piece of paper with some initials on it.
Right, Justice Rosen. I think it's still relevant because it has a tendency to show that he was told he needed to take those classes, which shows the seriousness of the DUI diversion.
And so that's where you get it. That's what it does.
Exactly, Justice Rosen.
He was told to take these classes, but doesn't say what they were or anything like that.
It doesn't make anything different than that.
Does it matter that you didn't close the gate? in terms of establishing that he actually took any of the classes, that he completed the diversion? I mean, that seemed to bother the jury, given their special question.
Sure. So, Justice Lukert, I don't think that matters. I certainly think, and the state argued at that suppression hearing and at the motion to dismiss, that we wanted to get into that. We wanted to have testimony about what do you learn at a MAD victim impact panel. But we think it is still relevant because it provides knowledge that if you commit a crime, it's both a criminal action, so you enter a diversion, so it would still be relevant to disregarding that state of mind to show extreme indifference to the value of human life under those Dobb factors. And the fact that you're ordered to take those classes still shows something must go on. The Court of Appeals framed it as, we don't need to speculate to go into that. Obviously, at those classes, there'd be something you'd learn about going on. We certainly think the better practice, and that's what the state asked for at the lower level, is let the state get into what those classes are. But going into kind of, well, the jury asked, did he successfully complete it? Well, that was an option for the defense to say is, look, he never took the classes, so this evidence isn't very relevant because he didn't learn anything about a DUI, so you shouldn't consider that Dobb factor. They had the option to present that defense. They chose not to. So we think it's still relevant, but I agree the probative value is not quite as high as it would have been if we could have gotten into what do you learn at a MAD victim impact panel, or did he attend those outpatient counseling classes. But still relevant to show the seriousness of DUI and the risks of driving under the influence.
Why?
Let's-
Oh, good. No,
I
go
was
ahead.
going to move to a little different issue, so Justice Rosen,
No,
if you're on
why
this
isn't
one.
that just knowledge anyway? Doesn't the general public, doesn't everyone know the seriousness of DUI? Does it take a prior, does that add anything to the general knowledge that people have of the dangers of driving while intoxicated?
Yes, Justice Rosen. I think that almost everyone in society knows driving under the influence is dangerous, but it's not a binary question. It's one of degree. There's a reason why they have MAD victim impact panels in the first place. They think they work. They think people will understand the risks of drunk driving, see that people, like the victim in this case, end up dying from drunk driving, and then it makes it less likely it happens in the future. So a better appreciation of the risk is less likely to make it happen. But I would certainly agree that almost everyone in society knows it's dangerous. People learn more about why it's dangerous in the first place.
I'm going to switch gears just slightly, but still on this general topic, and that is assume that we disagree with you and say this evidence should not have been admitted. So I'm going to move you to the harmlessness test. We have heard from opposing counsel, as I recall, she said that this evidence went to his right to a fair trial. That is a constitutional right, therefore we apply the constitutional harmlessness test.
And
Tell
so
me your response to that.
Absolutely. Chief Justice Nuss, we disagree with that. I think the prejudice prong would frame that, and I'm going to come back to that in a second because I think it would frame harmlessness. But to answer your question directly, we think the evidence would still be overwhelming in this case. It's not a constitutional error because basically their argument would devolve down to it is a trial error, as Justice Lukert was asking about, saying how do you delineate then what's a constitutional error and what's just every error in a trial becoming a constitutional error. Here it didn't deprive him of his right to a fair trial, didn't lower the state's burden of proof, didn't deprive him of a right to confront witnesses against him. It is just the standard run-of-the-mill 6455 evidence in a case. It's no different than anything else, and this court consistently in Torres, Gunby, and in Boysaw, one of its most recent decisions has held that the 6231 standard applies, the statutory one, not the constitutional one. I don't think there is any bright line this court could draw where every 6455 case would not become constitutional error under their framework. The statutory scheme has to exist sometimes, and it does here. Now, if the prior were admitted and an officer took the stand and said, well, I know they were guilty because probable cause is the real standard, maybe then we get into a discussion about did that confuse the jury. I still think they're probably not even. But certainly in this situation, we don't think that that's enough. But we also think the facts, even if it were a constitutional standard, are enough that the DUI would not be so prejudicial that it would be beyond a reasonable doubt that that would have impacted the verdict. The facts were just overwhelming in this case. Even if he hadn't driven drunk, the fact that he went 90 plus miles an hour in a 40 mile an hour zone caused a man to fly through, or his vehicle to fly through the air, caused a man to die a month later, didn't get out of his vehicle at the scene, one of those Dobb factors to look at. All of that is overwhelming evidence. He is a .211 an hour and a half after he leaves the last bar at 10 o'clock. That is just overwhelming evidence of recklessness. But I do want to turn back to that prejudice prong because I think the degree of error kind of frames what's necessary on harmlessness. And here, the general problem often with 6455 evidence is its propensity evidence. You did a crime once, you've done the crime again when we offer it. But here, they conceded that he was guilty of DUI, which is a big issue, right? They conceded he was over .08, he was incapable of safely driving a vehicle. So if the jury gets back there and they think, he did a DUI in the past, he must be guilty again. Well, they conceded he is guilty of the DUI again. So that kind of normal problem we have with 6455 evidence really isn't present here because they admitted he committed that act earlier, so the difference and concern that he must have done it again isn't present. We think that that evidence is overwhelmingly good enough on the harmlessness, but we do think it was probative for several reasons. The Boysaw factors this court looked at include how clearly the prior act was proved. And in this case, the diversion agreement was entered into evidence. There was no question it happened. Some 6455 cases, the state will bring witnesses on, and maybe the case isn't proven the most strongly. But here he signed the diversion agreement, admitting he had a prior DUI. Also, it was how seriously the material fact was disputed, and it was the main argument of the trial. They said we're not guilty of second-degree murder. The state said that is the main evidence we have. The main evidence we have, and the main question we have is whether he showed extreme indifference to the value of human life. So we think the probative value is pretty high for this DUI, but even if it's not, all of those Dobb factors are still overwhelming on the consideration of harmlessness. States 35 shows the damage of the wreck and how it spiraled out for hundreds of yards. States 37 shows the map, which allows the court to look at just how far this wreck was. So for Mr. Claerhout to either be in a world where he had no idea he hit somebody and caused all this damage shows how reckless he drove, or it shows that he didn't render aid when he should have known that he hit somebody. One of the individuals in the car mentioned that he thought they hit a white box, and he described it at trial like one of those pods you'd load into if you're moving. That provides some evidence to say that he probably should have known that he hit somebody. If you're in a residential street and you hear a loud thud, you probably should know you hit somebody. Maria Alves and some of the other witnesses mentioned hearing loud sounds and being concerned like it was a car wreck. That was strong enough evidence to know you had to render aid. If there are no additional questions on that.
I had a question.
Sure.
What if we change the facts slightly and he passed out because of all the alcohol he had consumed and then hit this other car and killed this individual? Can that be considered reckless since he didn't have any consciousness, did he?
Chief Justice Nuss, we think that would still be reckless because the reckless act would be getting in the vehicle in the first place and then hitting somebody, if I'm understanding your hypothetical correctly. So it's the act of getting in a car and driving in the first place that creates that. Now, if there were a sufficiency challenge, we wouldn't have the Dobb factor about failure to render aid because the person's not conscious in the first place. They couldn't maybe fail to render aid under that Dobb factor, so maybe that would be a different analysis. But in this case, he was completely conscious. None of the two passengers said he lost consciousness. They heard everything that was going on. So that is an additional fact for the state to have for harmlessness that makes this even stronger than one that would still be plenty for reckless second-degree murder.
Would the facts that the Chief Justice just recited to you impact the voluntary intoxication defense? Would that be an instance in which it might be appropriate if someone is so intoxicated they pass out, they don't even realize they're behind the wheel?
I don't believe so, Justice Rosen. I think with recklessness and certainly under depraved heart murder, the consideration is, does someone put themselves in a circumstance where they'll allow a thing to occur that could kill somebody, whether it be Russian roulette, or if you know you get so drunk you like to pull out a gun and think that you can, time the bullet correctly, or if you get so drunk you might get in a car and kill somebody. That's the problem. So that's why we think it's just never a defense to reckless second-degree murder. Maybe that's a different thing if the court wants to draw a fine line, but this is why we say these lines are so tough to draw, we'd ask the court not to draw them in the first place.
Do we have any further questions? What are you asking us to do?
Chief Justice Nuss, we are asking the court to affirm the Court of Appeals decision upholding the jury's finding that Jeremy Claerhout was guilty of second-degree murder. Thank you.
Thank you, counsel. Counsel, before you begin, would you address the question that Justice Rosen and I were asking opposing counsel, and that is if somebody had just passed out because of the consumption of alcohol, could that be a conscious disregard to risk?
Of course. And what occurred to me actually as you were talking about that is, what about a situation where someone was, what we consider blackout drunk, but still moving, which we know that those cases happen where you're still walking around but then the next day you have no memory of anything that happened or anything that you did. I think that person would clearly be entitled to a voluntary intoxication instruction because it all comes back to the plain language of the statute, which is that to commit reckless murder, you have to be able to consciously disregard a risk. And if you can't consciously disregard that, whether you're up moving still or whether you are actually physically passed out, I don't know how you can commit reckless second-degree murder. And in fact, if you look at the statute that describes criminal mental states, it's interesting because for intentional, and this goes back a little bit to the specific general distinction, but for intentional crimes, the legislature specifically says that these are specific intent crimes. For knowing crimes, the legislature says they're general intent crimes. Reckless doesn't say one way or the other. So that, to me, means that there has to be some circumstances, at least, where you would get a voluntary intoxication instruction possibly on reckless crimes. Now, whether that's in all crimes or some crimes, I think maybe the court doesn't need to decide that today. I think it definitely would have been true for this crime. And that's what we're asking the court to find. Just to go to the 455 issue very quickly. I kind of meant to mention this before, but didn't. If you go back to Gunby, and Judge Green talks about this in his dissent, one of the sort of standards for using a prior bad act is that the crimes actually have to be similar. And here, his prior DUI was not at all similar to this crime. So to the extent that we're admitting it just for the fact of the DUI, which is what the district court at least said they were doing, these are not similar crimes at all. So just going back to that basic tenet there.
Counsel, that may cut in your favor on the admissibility, but the state makes what I understand to be the exact same argument on harmlessness to say there's no propensity problem here because it's not the same crime. In other words, it's the earlier DUI was admitted the second time around, so no propensity problem whatsoever.
I think he admitted this DUI the second time around, not the I think he was forced to admit the earlier DUI, I guess, by the court's rulings. And also the jury didn't
he signed the diversion agreement.
He signed the diversion agreement, but the jury didn't have any information about the nature of the prior DUI. They just knew that he had a DUI. For all they knew, he could have hurt someone. Generally, I think you would believe that prosecutors wouldn't give a diversion agreement if someone was seriously hurt. We know that. I don't know that.
Let me rephrase the question. What is the propensity harm, or what was the propensity harm to your client to admitting this evidence?
Because it made it look like he was someone who regularly got out in his car and drove drunk. And as a juror, I think we could all see a case where they would feel like we have to put him away for as long as we possibly can to protect other people, not because he's guilty, but in a community sympathy or community safety function, which is outside of what the jury was being asked to decide.
Even though there was a limiting instruction on how to consider this evidence.
Yeah, I think, I don't know.
And even though the jury already knew that he was agreeing to being punished.
For this crime.
For this crime, he was admitting that he would, and they had no information that would tell them, would they, that one was a more serious crime than the other?
They wouldn't, but I'm not sure how that.
Well, you were just saying that it would compel them or motivate them to want to punish him for a long time. Mm-hmm. They already were going to be doing that.
They were already going to be and they were going to be punishing him for the crime that I would argue he committed here, which is DUI manslaughter, which is different than punishing him for second-degree murder.
It just seems that it changes the propensity calculus when that jury was already going to be punishing him, sending him away. It takes away that aggravation. Well,
but the state's whole case for aggravation was that he had this indifference to human life, and I think the prior DUI, maybe arguably goes to show that, because it makes it look like he was a repeat drunk driver. I guess I just keep having to come back to that. I see that I'm out of time. If there are no more questions, I would just ask the court to remand this case for a new trial.
Do we have any further questions? All right, thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.